This morning, what we're going to do, I'm going to first introduce our panelists and then set the table for this topic, which really, as you might know, gets my blood boiling, but I'm going to be an impartial and neutral arbiter between these two gentlemen who we are very, very lucky to have discussing this important issue. So we'll start by introducing, to my left, I have the newly minted Justice Lawrence Sawson, who graduated from Osgoode Hall Law School in 1992, was a law clerk to former Chief Justice Antonio Lemaire of the Supreme Court of Canada, former associate in law at Columbia Law School, and has doctorates from the University of Toronto and Columbia University. He was a professor, as you know, for many years, both at the University of Toronto and at Osgoode Hall Law School. 2010, he was, of course, appointed Dean of Osgoode Hall Law School, and just this past year, just in December, of course, was appointed to the bench. So we're very lucky to have Justice Sawson here as he begins his transition into his new life, so thank you very much. And to my right, a similarly distinguished guest, Justice Lauwers of the Ontario Court of Appeal, graduate of University of Toronto's Law School, and also recipient of a Master of Laws from Osgoode Hall Law School. Before being appointed to the Ontario Superior Court, he was a partner at Miller Thomson, significant practice experience in the areas of civil litigation, administrative law, constitutional law, human rights, the list goes on. And he was appointed to the Court of Appeal for Ontario in 2012. So with that, I will briefly set the stage for this important topic. So for those of you who are unaware, what we're talking about today is the approach that a court takes when it's reviewing a decision of an administrative tribunal or administrative decision maker for its constitutionality. On one hand, we know that when a law is challenged under the Constitution, we have a two-step framework for how we deal with those sorts of challenges. We have the claimant's burden to make out whether or not an infringement has been made by the government, and then the onus shifts to the government to justify that. I'll call it an infringement, but there's, of course, issues about that now because of the dissent in Frank yesterday. But the onus shifts to the government. And it shifts to the government under the umbrella of the Oakes test, which is a proportionality measure between the objective of the law and the means used to implement the law. And for many years, this was also what we thought the approach was when an administrative decision maker's order or decision was challenged on judicial review. On the other hand, then came Doré. And Doré decided to shift the way that we deal with these sorts of challenges. And it did so by essentially implementing two steps. The first, it's unclear now that an administrative decision maker has to concern itself with charter rights. Rather, what the administrative decision maker is asked to do is to consider charter values. And in Doré, charter values was defined as the sorts of things that underpin a right and give it meaning. So that's step one. Step two, there has to be a proportionality between the objective of a statute under which an administrative decision maker makes a decision and the charter value at issue. And it's unclear, and we're going to explore this today, what the relationship is between that proportionality analysis and the Oakes test. So immediately, with that posture set up, we could see the issues that could arise when we're dealing with charter values, and we saw it in the recent Trinity Western case. Number one, what are charter values? Are they distinct from charter rights? At the lower court level, how do courts apply Doré and TWU? Importantly, at a more theoretical abstract level, does this Doré balancing test weaken the force and the strength of constitutional rights? And what does Doré say about the legitimacy of the administrative state in our constitutional system? And what was typically the province of the courts to say what the law is when it came to constitutional matters? So these and other important issues we're going to deal with today with our esteemed guests. So with that, the posture that we're going to take today is, I have a number of questions that we've all agreed to among the panelists. I'm going to pose the questions to the panelists who will then answer, but we'll begin with some opening remarks from each of them. And we'll start with, to my left, with Justice Sawson.
Well, thank you, Mark, for the introduction, for all the work organizing this panel, to the Remedies Society for having me back. It's a terrific room in all senses of the word. This is one of my favorite spaces in the country for discussion, and I've had the chance to be at many events here, including other Remedies Society gatherings in smaller rooms upstairs at Hart House. So every time I see this organization, it's growing, it's including more in the discussion, and it's engaging in discussions, like Adam said, that we need to have. So I'm glad to be here. I'm especially glad to share the reflections on this topic with Justice Lauwers. What Mark could have added to his bio is that he spent a very energetic year as the judge in residence on a study leave to Osgoode Hall Law School that coincided with my last year as dean, and Justice Lauwers was a force at the school, participating in all manner of classes, discussions, engaging with students, engaging with ideas. And it was terrific to begin these conversations about charter values, for example, in the administrative law class I was teaching that year, and then see his thinking evolve in some of the Ontario Court of Appeal decisions he's participated in. And I just want to say, and I think the earlier panel's reference to charter values made this clear, that it's not nothing for Justice Lauwers to come to a room like this and express concern about charter values. I mean, the love and affection for this idea is so evident in this room. You feel it washing across every table, and it takes, frankly, guts to come, and notwithstanding that, speak his truth to this power. And it's one of the many reasons I admire him so much. But he's an experienced hand as a thought leader on the judiciary, speaking at events like this. It's, of course, fresh territory for me. So, I should add a caveat that while I've written and shared comments on this topic, and will speak to it with those perspectives in mind, in this new role, in the weeks of my judicial career, I haven't come across a charter values issue. I don't know how I would approach it in light of all the circumstances and contexts that might come before me. So I'm sharing really the fruits of the ongoing jurisprudence and discussions, but of course need to keep an open mind in that other context. So the last thing I wanted to share about charter values in particular is how much I've benefited from the writing and commentary of both the judiciary and the academy, and lots of observers who care about cases like Trinity Western, like the discussion we just had. And I think keeping in mind the comments Adam made, that this is a topic that can inspire pretty strong divisions, strongly held views, and I think it's good that it does. But at the end of the day, I think there are more shared values than divisive ones about trying to work out the proper mechanism for accountability for all the myriad of government decisions, discretionary decisions that shape the lives of so many people. And I don't want to lose sight of how much this matters to those individuals and communities, because there's a tendency in this topic especially to worry about the angels dancing on the head of a pin and the metaphysics, as Justice Binney once referred to the standard of review, and you get caught up in the ideas sometimes to the exclusion of why this matters. So I know we won't do that today, and I look forward to the discussion and the questions. Thank you very much.
Thank you. You can see Lauren's a silver-tongued devil, and he's going to be a formidable person to hear today. It's a pleasure to be here with you. You may recall that last year I was a keynote speaker on the subject of charter values, a subject that in fact started me down that road with Lauren's class. A year later, if you're a charter values supporter, you've had a very good year. But if you're a charter rights supporter, maybe not so much. Before heading into the subject matter of this panel, let me express my delight that Lawrence Sossin has joined the judiciary. His contribution to administrative law and to legal education, his deft management at Osgoode Hall Law School, are rightly seen as legendary. He was there at the outset of the extended conversation about charter values. My admiration for Lauren is real, just as is my disagreement with his approach to charter values. So why worry about the role of charter values in judicial and administrative decision-making? After all, what could go wrong if decision-makers like judges, tribunal members, and bureaucrats consider the implications of dignity, equality, liberty, and other such values in making their decisions? After all, aren't these the moral goods on which we have agreed as a society? Well, that might be, but I worry about this troika: the advent of unbridled charter values, the requirement of deference to first-level courts and administrative tribunals, and the increasing resort to proportionality analysis in resolving charter cases under Section 1. The exercise of discretion is necessary in a modern administrative state, but it must be prudently constrained. So when a decision implicates charter rights, we know we are in important territory. Because constitutional rights are involved, we think there must be one right answer, even though that might be difficult to discern in any particular case. So I worry about administrative law deference being required, especially since the Supreme Court in TWU has found that charter values can, in fact, trump charter rights. My thesis is that giving charter values broad scope in judicial and administrative decision-making could work to undermine the settled and stable elements of our contemporary understanding of the rule of law. Those serve to protect individuals and communities from the arbitrary exercise of state power. So this has two possible ramifications, perhaps three. On the one hand, excusing the state actor from providing a full demonstrable justification of a limit on a charter right, it seems to enhance state power. That's the first move in Doré. On the other hand, treating charter rights and charter values as equivalent seems to lead to more restrictions on state power. That's the second Doré move. And the third move, of course, is the whipsaw between those two positions that we're going to be subject to in the next while. So I worry about magnifying enormously the discretion of administrative decision makers and first instance judges, even ones as well-intentioned as Justice Sawson, well beyond the reach of the rule of law for two reasons. First, we know that human beings need rules and can't be trusted with unbridled discretion, judges included, me included among those judges. I don't exempt myself from any of this. Second, the separation of powers exists for a reason. The de facto amendment of the Constitution by discretion is not how things are done in a liberal democracy. So, in my view, while charter values do have a modest role to play in decision-making, it should only be a modest role. From where I sit, it's time to put the charter values genie back into the charter rights bottle.
All right, thank you. So our first question, we're going to start at a sort of a higher level of abstraction here. We know what the Doré TWU approach says now, holds that a distinct administrative law approach to addressing charter rights in the context of an administrative proceeding is preferable to the classical conception of the Oakes test. So for each of my panelists, I'll just generally ask, what are your thoughts on this move and this administrative law approach?
So I'm going to go first on this one. Mark's already outlined the traditional analysis. Step one, prove the breach. Step two, state actor justifies it under Section 1. That's typically what happens. It doesn't happen that way in admin tribunals as a result of Doré. So just to go through a bit of the evolution briefly, discretionary decision makers are obliged to take the charter into account. In Slate, the Supreme Court simply applied Oakes. The idea of a special administrative law approach was raised by Chief Justice McLaughlin and Hatarian Brethren. It was pursued in Multani by the Justice Abella and Deschamps in their concurrence. But speaking for the majority, Justice Sharon saw great risks in departing from Slate. She said this: I'm of the view that this approach could well reduce the fundamental rights and freedoms guaranteed by the Canadian Charter to mere administrative law principles, or at the very least cause confusion between the two, and that led her to say that the administrative law standard of review is not applicable to the constitutional component of judicial review. 2 years later, she's gone, and along comes Doré, and this is where we have the administrative law approach laid out. So in admin law cases where the charter protections are implicated, the tribunal need not undertake the more rigorous charter analysis demanded by Oakes. Justice Abella held that the administrative law framework and the Oakes test could be reconciled in the proportionality calculus. She stipulated that in applying charter values in the exercise of statutory discretion, an administrative law decision maker balances the charter values with statutory objectives. She set up a two-step process in which the decision maker should first consider the statutory objectives. Second, the administrator should decide how the charter value at issue will best be protected in view of the statutory objectives. So the majority in TWU announced its expectation that the tribunals would carry out what they called a robust, and that word I don't like that much, and it's italicized in the original decision, just to make sure we really get the message. A robust proportionality analysis consistent with administrative law principles that works the same justificatory muscles. So, nice tone, eh? As the Oakes test, not a watered-down version. But she went on to say that a reviewing court must give deference, that is, a margin of appreciation, to administrative bodies and how they balance charter values against broader objectives, and that was picked up in TWU by the majority. So when does the administrative law approach apply? It applies when the rights claimant is challenging only the decision itself, not the provision that authorized the decision. So if the provision is challenged under the charter, then the full process, traditional process applies, but if it's just the decision, then not. That's the bright line set by Doré and repeated in TWU. Actually, I'm not sure that bright line is all that bright, and I don't think it's sustainable in the longer term. It's not clear to me that there's any reason to treat a challenge of a provision differently from a challenge to a decision. In fact, there are good reasons not to do so. The effect on the claimant might not be different. So I'll stop at that point and hear from Lauren.
All of that's helpful, especially walking through what the charter values approach is. So I won't rehearse that. I think Justice Lauwers has done an excellent job both in laying out that approach and why it's been seen as problematic by many who've been analyzing the line of jurisprudence on the charter involving discretionary decision-making from Slate onwards. In Doré, Justice Abella talks about the conflation and hope for coherence between two different approaches. One is that charter line of cases involving discretion and some of the issues she had already laid out in Multani indicated her anxiety about the application of the Oakes test, and we'll come back to that in another question. But what gets lost in the shuffle, and what is, in my view, vitally important to keep in mind as we explore where this is going to go and where it's come from, is the other line of cases that this is intending to bring together, not the charter cases, but the administrative law cases. And I'll refrain from adding mere or robust to administrative law in this context. But it's a very important line of cases, certainly, in my view, important to what is of value to carry forward in this line of thinking. And I think the most important case in that line of administrative law decision-making is the Baker decision, which is about to celebrate its 20th anniversary, a 1999 decision, and a quick plug to an OBA Institute session coming up on February 5th, looking at the 20th anniversary of Baker. It's a case we ought to come back to more often in this discussion for two reasons. First, it set out that where you have both administrative law and charter issues raised, and I should add that charter issues in that case were fully argued and many saw it as a pivotal charter case in the making, you may, in fact, find it can be resolved, whatever the dispute is, on administrative law grounds, and where that's the case, one ought not to then go on and go through the charter analysis. So Justice Lauwers in her first lines of analysis in Baker says, there are charter issues and they're important ones. We don't need to deal with them because the administrative law analysis is sufficient to dispose of this judicial review. And in so doing, I think it's important to pay attention to how the unanimous court on these issues viewed that administrative law analysis. And I want to just take you to the pivotal paragraph in that decision, paragraph 53, where Justice Lauwers wrote for the unanimous court, discretion must still be exercised in a manner that is within a reasonable interpretation of the margin of maneuver, as you've heard, contemplated by the legislature, in accordance with the rule of law, citing Roncarelli and Duplessis, in line with the general principles of administrative law governing the exercise of discretion, and consistent with the Canadian Charter of Rights and Freedoms, citing Slate. Subsequently, she puts it this way in a passage that has often been puzzled over and not fully elaborated, but again, to me, plants the seeds for the Charter values administrative law approach to come. She writes in paragraph 56, though discretionary decisions will generally be given considerable respect, the discretion must be exercised in accordance with the boundaries imposed by the statute, the principles of the rule of law, the principles of administrative law, the fundamental values of Canadian society, and the principles of the Charter. And so that idea that administrative law, because its origins are in the common law, what the UK and other Commonwealth countries often refer to as a common law constitution, because it needs to grow in the way the common law does to reflect the society in which it's emerged, then of course how we understand reasonableness, how we understand that ambit for discretion must similarly take on board those principles or values arising from the Charter. So that aspect of the Doré approach, and I would argue the concerns arise not on the administrative law approach leading to a finding of reasonableness, but actually arise on the view that that somehow precludes a Charter rights analysis. Excuse me, that, in other words, the administrative law approach, I don't think is the mischief. Certainly no one has shared with me deep concerns over why reasonableness in the administrative law sense shouldn't include those kinds of Charter values. The concerns that are often expressed is the idea that somehow where Charter rights are engaged, they no longer will be subject to a Charter rights analysis, that it will only be the Charter values analysis, and I'm not sure where that view necessarily derives from. So, like Baker, I think the proper way to see this, and I'll elaborate this further, is that if the administrative law approach can resolve a challenge to a discretionary decision, it ought to be invoked and is all that ought to be invoked. And only in those situations where it cannot resolve the matter would a Charter rights analysis remain important and relevant and ought to be available. And we'll see as we look at cases like Loyola and Tunaha and others, where there's been important decisions by different constellations of judges to look at the same discretionary decision either through a Charter rights lens or a Charter values lens subsequent to the Doré decision. So I'll leave it at that, but we'll come back to these issues as well.
Thank you. That's a great lead-in into our next point, which is really the meat of the matter. We know in the TWU hearing, Justice Brown asked counsel point blank, what are Charter values? And indeed, that's our question today. So my question for our panelists is, what do you understand Charter values to be? Are they distinct from Charter rights? And a little bit more in depth, does the use of Charter values undermine the propulsive approach to constitutional interpretation? And this, of course, was an issue raised by Justice Rowe in TWU.
You want me to go? Sure, okay. So the least radical form of a definition, I suppose, was put in Loyola, where Justice Abella said that Charter values are those values that underpin each right and give it meaning. So this seems at one level to pin Charter values to Charter rights, but my take on things is that the pin has clearly come out. Consider this ostensibly benign list of Charter values that Justice Sawson extracted from the reported Supreme Court cases in a well-regarded article: liberty, human dignity, equality, autonomy, fairness, expressive freedom, and privacy. And then there are more Charter values in the jurisprudence taking the broad view. Supreme Court of Canada has identified a list of cardinal virtues in Oakes, like respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, faith in social and political institutions which enhance the participation of individuals and groups in society. The court later added autonomy, liberty, equality, and human dignity, And there are some candidates from the Quebec secession reference, including federalism, democracy, constitutionalism, and the rule of law, and respect for minorities, perhaps interdependence. The list of charter values would appear not to be closed. People argue that diversity and inclusion are charter values. We've had some of those cases in our court. No doubt there are other possibilities. What about pluralism? Of course, that's a difficult one because then you have to decide whether you want convergence pluralism or accommodation pluralism, which are two different concepts altogether. How about effective representation? There's one that Justice Belababa found in the City of Toronto challenge to the province's reduction in the number of city councillors. So Justice Austin, as an academic, encouraged tribunals with discretionary powers to use recognized charter values or potentially a novel value analogous to an existing charter value in discretionary decision-making. The next move would be to deploy those charter values, even the novel ones, as though they were the same force as charter rights. Is that the right approach? So from my perspective, I have no trouble with using charter values as the Supreme Court of Canada has done in interpreting the Charter, developing the common law, and interpreting statutes, at least so far. Who knows what they'll do in some other case coming up. I have some real concerns about the way they use charter values in exercising their discretion in administrative law, and also with conducting proportionality analysis under Section 1. Just to start the ball on that one. So.
I got to say, I like this order of speaking. Something tells me in my present role, the times in which I'll have the last word in relation to Justice Lauwers may be few and far between. So this is good. You know, it's an important question, and it's one too many dodge, because once you start enunciating any specific values that are not captured in the words of a right, you run the risk of either a sort of judicial usurping of a role that was intended to be committed to the text, or you run the risk of simply incoherence. And we saw a similar debate around the unwritten or underlying constitutional principles that's continued to play out since the secession reference at least. But in relation to charter values, I think there is firmer ground on which to rest these ideas. And I, again, hearken back to a decision that is a precursor to this other line of approach of the court in Dore, which is the Hill and Scientology decision, in which another common law principle, in that case involving defamation, was analyzed in relation to an allegation not that it violated a specific charter right, that common law rule in relation to that tort, but rather that it was inconsistent with broader values underlying the charter. And in fact, the court, I think it was Justice Corey, in that decision, said historically the common law evolved as a result of the courts making incremental changes where necessary in order to make the new law comply with current societal values. The Charter represents a restatement of the fundamental values which guide and shape our democratic society and our legal system, and it follows that it is appropriate for the courts to make such incremental revisions to the common law as may be necessary to have it comply with the values enunciated in the Charter, not comply with a specific charter right through a specific methodology of charter litigation. And so given, for example, the preeminence of the concept of human dignity throughout so much of the first 3 decades of charter jurisprudence, I don't think it's contentious to suggest that that is an underlying value, apart from the fact that you do not find those words set out in any specific charter right. It's there in the preamble, of course, but I think that notion I should say it's implied in the preamble, but you don't find those words spoken in a direct way anywhere in the Charter. And I think similarly, we can pick up on other ideas like privacy that is implied by protections against search and seizure and other kinds of charter rights. So the charter right has to be the point of departure. It can't be a free-floating inquiry into what I personally think a fundamental value is, and it ought to be the subject of rigorous advocacy and ought to be the subject of lots of debate and discussion within and among the parties raising these issues, courts deciding them, legislatures certainly can have a role in elaborating these as well. So I'm not, just as I think you shouldn't sweep this under the rug and say, well, we'll get to it, it'll be whatever someone thinks it is in the moment, I also don't fear ideas that we have not fully fleshed out. And I'll come back to this idea because it's animated so much administrative law over the years, that there is a common law methodology to working out important principles, fleshing them out in context over time, refining them and course correcting where we don't get them right. So I don't take that to be a reason not to pursue this avenue of conceptual thinking. It's certainly well grounded in the court's jurisprudence long before Dore. It's just a matter of doing it in a way consistent with the challenge and elaborating it so that it can be tested against the important critiques that will come from various quarters.
Thank you. So the next question, assuming that there is this split between those who endorse an approach based on charter rights and those based on charter values, do you feel that it's significant for practical purposes? Does it matter?
Maybe I'll
I'll
go first on this one, just because I have a very brief point to make, which is that I do struggle to understand the distinction, and I take seriously lots of commentators who've pointed out this could be a watering down of charter rights, that it's much easier somehow to justify the proportionate balancing in a charter values Dore sense than the rigor of the charter rights and Oakes test. And I frankly just don't see it. In other words, I struggle to understand the circumstances that are going to give rise to a finding that a decision was reasonable in the administrative law sense, but nonetheless unconstitutional under the charter, or vice versa. And certainly Loyola stands as a great example of how very smart judges pursuing diametrically opposed methodologies on this issue arrived at a very similar decision. And certainly Justice Rowe versus the majority and again Chief Justice McLaughlin, the concurring, the majority, there were different important differences in approach, but ultimately that set of findings upholding the two law society determinations speaks to how rare it would be to imagine a distinction. As I said earlier, if there is such a setting where the charter values analysis would, let's say, lead to finding of reasonableness, I would have no concern with going on then to have that charter rights analysis. A charter right should not go unvindicated, and there are real concerns about the shifting onus between whether it's the state actor justifying the action or the party impugning the action having to prove the proportionality balancing was not met. But again, I think those are mostly distinctions without a difference in the circumstances that I've seen and can easily conjure. I wouldn't want to make that a universal assertion. And again, I think there ought to be a way in which, where those rare circumstances do arise, that full charter rights analysis is available for some of the reasons that Chief Justice McLaughlin well articulated in Trinity Western, that ultimately there can't be a methodology for understanding the charter that doesn't allow someone to vindicate their charter rights under the existing charter jurisprudence. I would add, if that's the only way to do so.
Thanks. I detect a certain more cautious posture in Justice Sawson's comments than I've read in his text, so it's a welcome nuance. So in TWU, Chief Justice McLaughlin noted that charter values may play a role in defining the scope of rights. It is the right itself, however, she said, that receives protection under the charter, and I think that's right. If you look at the actual wording of Section 1, you won't find the word value in there anywhere. She was responding, of course, to the majority's move to conflate the charter rights and charter values into charter protections for analytical purposes. So I think the difference is important. I'm going to make 3 points. The first is that there is a list of charter rights, and it's in the charter for all to see and to reason about. It represents the Canadian constitutional settlement. There's no such list of charter values. There's no definition of what a charter value is and no method for proving its existence. The lack of specificity in charter values should not be a surprise. The rights in the Charter were developed carefully through the democratic process of debate and rest on a substantial legal background before they were formulated. Some of the things that we now call Charter values may well have been rooted as a possibility to be a Charter right, but were left aside in the settlement because they were uncontrollable or ungovernable. So that same public attention that gave rise to the rights we now see in the Charter has not been paid to Charter values, and it will not be. The common law process that we think works so well for tweaking tort law will not work when it comes, in my view, to Charter values. What we will get are random complaints handled by random lawyers or self-reps, more likely, in a lot of cases, heard by random tribunal members or single judges, but the results will be binding on many through deferential review and stare decisis. This is no way in a liberal democracy, in my view, to develop binding constitutional norms. The institutional capacity to do the work in a consistent and deliberative way is not in ad hoc tribunals or courts, but through legislatures. The second point is this: excusing the state actor from providing a full demonstrable justification of a Charter right limit seems to enhance state power. As I said earlier, that's the first Dore move. If the state does not clearly have the onus to justify the limit on the Charter protection, then the claimant could be disadvantaged because the debate is immediately about proportionality, not about whether the statutory objectives were pressing and substantial, or whether the means chosen were rationally connected, or whether they were minimally impairing. In effect, the claimant under Dore, the first move in Dore, is faced with a quasi-presumption that the limits on his or her rights are justified. The language suggests that the statutory objectives have indefeasible priority over Charter rights, which would be contrary to the Oakes methodology, not a good thing. But this is offset by the second Dore move, which I mentioned earlier, treating Charter rights and Charter values as equivalent. That seems to lead to more restrictions on state power. So it's a bit of a whipsaw. But here's my prediction on how things will unfold. My guess is that it'll go this way. Claimants will assert Charter values in addition to Charter rights, and tribunals and courts will go immediately to the last step of the proportionality analysis. That minimizes the analytical discussion and the rigor and the work, and it maximizes the scope for discretionary action. The third point is this: in my view, the rule of law would be compromised if the authority of adjudicative tribunals to consider Charter values were coupled with the deferential standard of judicial review that requires tribunal decisions only to be reasonable, not necessarily correct. The troubling prospect, and it's been raised in several cases, is that two panels of different tribunals or panels of the same tribunal could disagree about the scope and treatment of a particular Charter value and reach results in a similar situation without supervising judicial oversight. The majority of the court in Saguenay did not think this was desirable and applied a standard of correctness to the questions of law concerning the scope of the state's duty of neutrality that flows from freedom of conscience and religion. Justice Gascon explained, "I find that the importance of this question to the legal system, its broad and general scope, and the need to decide it in a uniform and consistent manner are undeniable. Justice Abella alone would have reviewed on the reasonableness standard. That is now, in my view, the active debate." So in Wilson versus Atomic Energy, the dissenting justices said this: when reasonableness review insulates conflicting interpretations from judicial resolution, the identity of the decision maker determines the outcome of individual complaints, not the law itself. When this is the case, we allow the caprice of the administrative state to take precedence over the general principles of normative order. So let me just posit the nightmare scenario. Two law societies come to an inconsistent decision on Trinity Western. What now? With the deferential standard of review, does the Supreme Court of Canada say, yep, you're both right? Can't be right, can it?
Well, let me, if I can just add a quick addition to that thought, because I think one of the things to keep in mind, and certainly I hope mitigates some of the nightmare that Justice Lauwers is laying out, or the potential nightmare, is to keep our eyes on not just the analysis and the challenges that you've been hearing about, but the outcomes. And as long as the Charter values analysis, as so far it has been outlined by the Supreme Court, leads only to administrative law remedies, and that's a key point to keep in mind. It leads to a finding of reasonableness or unreasonableness, which then would either uphold or quash a decision. There's no other charter remedy so far that has been made available through a charter values analysis. And as long as that's the case, my worries go substantially down in whether it's the consistency of decisions or the concerns with respect to rights, because the key right that worries me, were it to be taken away, and what leads me to think there needs to be this residual access to a charter rights analysis if a charter values one does not prove to be effective or sufficient, is because I don't think you can say to a party that you will be denied under any analysis access to charter remedies, notwithstanding a violation of the charter has been found. So I think, again, in the overwhelming majority of cases, quashing that decision, doing exactly what the administrative law remedy provides, is going to be exactly what's needed. But there are other Section 24 remedies available if a discretionary decision is found to violate charter rights. And I don't know that the court's ever turned its mind to the justification for removing for all time, in every case involving a discretionary decision, access to those remedies. And as Justice Stratus, who I think is still somewhere in the room, reminds us every time he speaks, we need to take seriously what courts say, but we need to take just as seriously what courts do. And there have, subsequent to Doré, been a number of decisions involving discretionary determinations in which the majority of the Supreme Court did not turn to charter values, but rather charter rights, in part because of that important remedial discretion. Tunaha being, for example, just one notable example, where while concurring Judge Justice Moldaver refers to charter values, the majority mentions it nowhere and proceeds to engage in a standard, if problematic, application of the freedom of religion in addition to the duty to consult and accommodate. So we shouldn't, in other words, take, if we take seriously the court's actions, the view that there is, for all discretionary determinations that engage charter issues, only one avenue available to the reviewing court, that of charter values. It both would make no sense in terms of removing and precluding other charter remedies in every case, and it's not what the Supreme Court itself has done subsequent to this convergence of these various lines of public law that we see in Doré.
I guess we'll see in a little while whether Doré, now having been put to good use in TWU, will end up under the bus.
Well, it's that bus is a complicated one, so I will look forward to seeing what happens.
So aside from the doctrinal issues, let's focus a little bit on what this means for litigants in courts and tribunals. Does the absence of a judicially sanctioned process for establishing charter values pose a problem for litigants, for courts, for tribunals, and perhaps most importantly, for the rule of law?
Want me to take a quick run at this?
Sure.
All right. So my answer here again is from an administrative law perspective, and it's again drawing on experience that we can all see tangibly in front of us, so we don't need to imagine hypothetical nightmares to come. And it arises from a decision that just marked its 40th anniversary, that of Nicholson, in the area of the duty of fairness. Prior to Nicholson, there was a very stable case law that said the rules of natural justice, that had very trial-like procedural protections on disclosure and oral hearings and the like, applied exclusively to judicial and quasi-judicial decisions of state actors. Everyone knew what it was, everyone knew what you got, and everyone knew there was a whole province, a messy, somewhat murky province of administrative decisions, policy decisions that a court should not come anywhere near, given the division of roles between the judicial process and the political process. And Nicholson simply took that entire way of thinking and said it no longer makes sense, that whole sphere of administrative decisions that have no judicial or quasi-judicial components to them were also going to be subject to something called the duty of fairness that again was further synthesized in the Baker decision. And that duty was going to change case to case, tribunal to tribunal. In fact, the same tribunal might have a different duty of fairness owed to a different party depending on the way it affected those parties. You're denying me a license, but I drive recreationally might be different than you're denying me a license and my livelihood depends on it. Well, everyone threw up their hands. This is madness. How could you possibly know what to expect? You're saying that I get disclosure to the file on a Monday, and in that same setting, I'm going to get disclosure to a summary on a Wednesday, and I'm told to look to a boilerplate guideline on a Thursday? That's not the rule of law. Can't work. And everyone thought in a year or two the court will come to its senses and move off it. But something different happened. Everyone started sorting it through, finding their way, applying it in settings, having appellate courts correct them or adopt that way of thinking, and in that common law methodology applied throughout the country, everyone started to figure it out, how that variable setting was going to work itself out in the myriad of new areas that were suddenly subject to these important common law, administrative law rights. And now, 40 years later, this is one of the most stable, well-accepted, well-regarded, easily applied, highly predictable areas in our entire public law. And it's often held up, I shouldn't say often held up, it's held up by me, as an important distinction to its ill-fated, often orphaned for love cousin, the standard of review, that also marked a 40th anniversary not long ago from the CUPE decision, that has not had any of that room for flexibility and variability, and again is not held in high esteem as we see in the trilogy just argued before the court. So the answer on charter values to me is look to what has worked and ask why wouldn't it work here? Applying charter values in a host of different settings, in a host of disparate contexts, working out the principles that are able to be discernible, transparent, that make sense to people in these contexts that work, and adopt more of them. And if there are outliers that give rise to muddled thinking, inconsistency, incoherence, move off those, which frankly is exactly what happened in the first decade or two of that fairness jurisprudence. So I don't see why we would not see that administrative law approach as giving us comfort as opposed to scary dreams at night.
Well, I do have scary dreams at night, not necessarily about this issue, but I have to say that perhaps what we had in Baker was a set of reasonably coherent and administratable principles. We do not have that arising out of Doré. We have no such. All we do have is this notion, this trumpeting of the concept of a charter value. It's open season in terms of creating them. Looked at carefully, and there are over 200 decisions, which I'll get to later on in one of the questions, that have talked about charter values in the last 2 years alone. So it's a hothouse of craziness, I might say.
But you should really say what you think. You shouldn't hold back, is what I think the goal is here.
So I remain impartial when it comes to an individual case. Just take as read everything that David Strata said on the first night. I agree with all of that in terms of the disclaimer. So what we see, I think, and what we're going to see more of is the subjective nature of decisions involving charter values, the lack of transparency in the reasoning process leading to their identification and adoption. As the dissent said in TWU, this is no more than a rhetorical exercise. Charter values is just a name for the space between the existing constitutional doctrine and the outcome that you want. So let me read to you some words by Peter Weston in his seminal article called The Empty Idea of Equality. Some of you may be familiar with it. He says this: although equality is derivative, people do not realize that it is derivative, and not realizing it, they allow equality to distort the substance of their decision-making. It gives an aura of revealed truth to whatever substantive values it happens to incorporate by reference. As a consequence, values asserted in the form of equality tend to carry greater moral and legal weight than they deserve on their merits. That is why arguments in the form of equality invariably place all opposing arguments on the defensive. So consider the role that a motivated advocate wants an identified charter value to play in constitutional adjudication. Labeled as a charter value, a concept gains immediate and perhaps winning gravitas. A cynic might say that the selection and labeling of a charter value in a particular case is intended to facilitate result-selective judicial reasoning. The charter values approach excuses the decision maker from the step of justification because all the normative work is done off stage in selecting the charter value in the first place. Advocates spend their time I was one not that long ago, it seems. Advocates spend their time constructing competing charter values to arrange the collision of dignities rather than engaging on the substantive issues. Invariably, the concept is being used to identify a particular moral commitment that the sponsor asserts is desirable and which should accordingly be given some constitutional weight. Never an explanation as to why that is. It's simply self-evidently good. And if something is a fundamental moral good, the thought runs, something that all right-thinking people must agree to, that in some way it must proceed from the Charter, which is our national commitment to a consensus of fundamental goods. And if it proceeds from the Charter, and even in a certain way like Charter values, then it must be a commitment that is both shared and beyond debate. So this is catnip to many decision makers, including judges. There's great joy in donning the moral mantle, putting on the white hat, something bracingly affirming about finding and labeling a moral commitment as a Charter value. Putting it romantically, perhaps, the declarant can be claimed to be standing midstream in the river of justice that flows from the Charter, saying, yes, I'm giving constitutional benediction, to something. This is an intoxicating exercise of power, and I think it's a problem. So much for Charter values.
I just picked up my robes the other day. I didn't even know there was a hat. So these are the kinds of things you learn when you come here. Let me address the issue this way, that if you accept the approach that I'm suggesting is implicit, although not explicit, in Dore, that it's a helpful way of enlarging and clarifying the administrative law approach from that original passage from Baker talking about fundamental values and charter principles unelaborated. We now have a much fuller elaboration of that in ways that I think are helpful to the reasonableness analysis, and that we leave a charter rights analysis in the traditional sense and with a hopefully revised Oakes test that addresses some of the concerns well laid out in Multani, a case referenced earlier, then I think it is a workable approach. And to those who think, well, can you have two methodologies or two ways of approaching the same act of discretion without giving into incoherence or duplication? I'd say we've been doing it for years. Cases like Suresh from 2002 had an important reasonableness analysis under administrative law, an important charter analysis under Section 7, and ultimately a unity of public law approach as the court in that case resolved the matter under a breach of fairness, the procedural component of Section 7, and said to understand that procedural component, we don't need to make it up. We can look to Baker, in which we've just laid out a synthesis of the common law right. So this idea of going back and forth, drawing on shared learning between constitutional jurisprudence, administrative law jurisprudence, and understanding the key and pivotal differences between them, especially where there is a statute and an expression by the legislature, not just government action at issue, I think is eminently workable and doesn't give rise to some of at least the extremes of the concerns that Justice Lauwers and many others legitimately have been raising. And let me finish with this. I much prefer that kind of approach to trying to fuse in a different sort of omelet the eggs together between charter values and charter rights, as the Chief Justice valiantly attempted in Trinity Western, calling something charter values that in effect mirrors in every respect the charter rights analysis, or simply seeing charter values as helping us better understand the rights but not being a separate methodology, again, I think ultimately may do more confusion than clarity to the way that public law can proceed than if we see these as conceptually distinct and in fact giving rise to distinct remedies applicable, I think, charter values in the overwhelming majority of instances, but charter rights importantly where it's needed with a justification for why it's needed. Just as Justice Lauwers made clear, if administrative, for the unanimous court, if administrative law can resolve the matter, then recourse to the charter is not appropriate in those discretionary contexts. I think that will keep the best parts of the charter values concept and application without giving rise to some of the meaningful concerns that have been expressed. So that's the workable, non-workable pathway through for me.
See, I don't think I agree with that. The rubber hits the road, I think, at the point of the standard of review, where this all kind of meets. And I don't think fusing two things or going separately down one road and then down another road is necessarily the situation that will work on the ground. I think it's more like an overlapping kind of exercise. So the Supreme Court has said that the tribunals must apply the Charter, and I don't see rolling that back anytime soon. I think that's the right outcome as a matter of public law. But I am concerned, and as far as I'm concerned, tribunals must be held to the correctness standard in decisions they make. That is, on the existence of the Charter limit, the application of the law to the facts, not any Section 1 decision they would make. There should not be deference there. So how do I say we deal with administrative expertise? This is it. Obviously, the area of a tribunal's expertise might affect the assessment of the facts relevant to the application of the Charter in a way that a court would not know unless the tribunal found the facts and did proper reasons explaining its findings. So I want the tribunal to make factual findings both on the existence of the limit and how it limits the Charter right in its view, and I also in respect of the costs and benefits under the proportionality analysis. So I want the tribunal to go through all the steps of the Oakes analysis, pressing a substantial, reasonable limit, rationally connected, and then the steps of proportionality analysis as well. All of those things on the facts. Tell me what is going on in the world. Tell me how this decision will impact on the world. When it comes to those factual findings, it's not clear to me that the standard of review should be correctness because they rely on the tribunal's expertise, which it has and the court doesn't have in their factual findings. So, any line decision maker, for example, like a school principal or a bureaucrat or a ministry representative or a hospital bureaucrat, should get zero deference when it comes to making a decision because there hasn't been a hearing. So the first time you get in front of anybody, it's at the court, and then it's a full-scale Charter analysis as far as I'm concerned. I would also be more leery of fact-finding by representative bodies that regulate without hearings, like law societies. If there's going to be a real adjudication with a full airing of the Charter issues in the traditional way, that is not like Doré, then I would find it easier to accept the tribunal's factual determinations, assuming the reasons hold up to scrutiny. So the difference between the standards of review are sort of shifting around. So fact-finding, I think, is entitled to deference, and that would be including an expertise of a tribunal. But I also think the application of the law to the facts is something that should not attract deference when it comes to the explication of a Charter right. I think that's where correctness must be the standard. But how that works out in the language is something that the tribunal is going to have to explain properly and justify properly, and that'll come to the court for review in due course. And of course, an interpretation of statute and an interpretation of the Charter in particular, in my view, attracts a correctness standard.
Yeah, and I think we moved on to a question that Mark was about to put to us on kind of wither deference. So let me respond again to an area I don't think we disagree all that much on. Certainly if the tribunal does apply a Charter rights analysis, as they have the jurisdiction to do in the overwhelming majority of settings where they have a question of law to be determined, then Dunsmuir in a whole line of cases is quite clear, subject to what's to come from the trilogy, that those determinations do not attract deference. The Constitution is not an area that judges lack expertise in relative to any administrative decision maker, and I don't think that's controversial. Justice Lauwers' work in saying, well, shouldn't we look to the setting and the context, isn't those areas where there is a hearing different than those areas where there isn't, or line discretionary decisions versus other kinds of regulatory bodies, and I fully agree, and in fact have have a whole blog post on how the standard of review should be much more deeply contextual than it is, and we'll see where the trilogy goes, because that argument from a number of interveners was put to them, that we shouldn't actually defer in the same way to all these bodies simply by lumping them into a category of administrative decision makers. But here's the point that I think I do differ on, that if what we're looking at is an administrative law remedy, finding of reasonableness or not, and we're looking at the balancing of the charter value with a statutory objective leading to that administrative law remedy. So here we're outside the context of a charter rights analysis that could lead to a charter remedy. Then I do think that expertise that comes from bodies which by definition have a policy mandate. There cannot be, we learn in Oceanport from 2001, an administrative body whose sole role is adjudicative. So if they are created precisely because of that additional policy mandate, then that does take it from the realm that courts have expertise in to a realm that by definition has to presumptively involve something else. I say presumptively because in all sorts of settings, making legal determinations either outside that policy expertise or affecting fundamental rights, we may well in those contexts say deference isn't appropriate, and the Law Society decision, is Trinity Western accredited, yes or no? The Vavilov case involves citizenship. Is it a yes or no decision? Fit uncomfortably in this realm of discretion, where we see a range of options. Where these are yes-no determinations by applying the law to the facts, again, I think context may well give rise to legitimate questions on why deference in those contexts makes as much sense as where I'm a labor arbitrator with a whole range of remedies and I choose this one because I know about labor and I know about arbitration. I'm not sure we want courts coming in to say, I know more about labor and more about arbitration than you. So that to me is an ongoing important debate, but again, there's more I agree with in what Justice Lauwers said than what I disagree with.
I guess the question I would have then, Lauren, is whether you think charter values should ever trump charter rights.
And I think the scheme, at least, that I've been advancing, where charter values is the first analysis, and only if the charter values analysis leads to an upholding of a decision, and there remains a charter rights claim, that a proponent can meaningfully say, but if only you had the reverse onus, or I need a charter remedy other than quashing. In other words, a reason why that charter rights analysis is then important to turn to, it ought to be turned to. So I would have the reverse. The charter rights is the ultimate way of determining the result if, in fact, the charter values analysis leads to an upholding of that decision. And again, we've seen that as a very conventional approach to the uniquely Canadian mix of public law with Bill of Rights, Quebec Charter of Human Rights and Freedoms, Charter of Rights, unwritten constitutional principles, federalism. We've got a whole hierarchy that has been worked out over time of what you look to first and why, and what you keep in reserve, if necessary, to turn to. And it hasn't led to incoherence, it's led to messiness from time to time, a working through of those ideas, but ultimately we found ways to have complementary public law schemes for accountability of state actors rather than conflict, incoherence, or unpredictability.
I guess by my reflection on that would be that so as I see it, you want to do the administrative law analysis first, as Doré sets it out.
Right.
Including charter values. And if the resolution is, you don't want to get to charter rights because you think they should be reserved for cases where they're applicable, but otherwise they should be avoided. You want to take a fairly conservative approach to the invocation of the charter, right?
And I'd want to have some practical argument on why, notwithstanding the resolution of the charter values analysis, there remains important work to be done in a charter rights one. And I can imagine those settings. As I said, different remedies applying, the reverse onus, those all become juridically important differences.
Yeah, the problem I'm having is where would that happen? Because a tribunal has a hearing on a particular day. It all goes in on that day. So how does that sort itself out in practical terms? You don't have a second kick at the cat. You only have one.
Right, and so there's same problem arises now where you have administrative law challenges and charter challenges.
Right.
As in Baker, before it was clear how this might work out, you argued it all. Baker and the Supreme Court, from that perspective, is sending a message that we're going to use the administrative law tools first and foremost unless and until that charter analysis is needed. So advocacy will be driven in part by the guidance provided in the courts. So it may well be, as a matter of argument, do you need to hear from me on the charter rights? And a panel will decide either we have enough reservations about the charter values approach to say yes, or we think the charter values approach and how it's been argued is sufficient. We don't need to hear from you on that. That's how it works pre-Dore. So that's not a new move. That's continuing where you have multiple remedial avenues, how we work out challenges of advocacy and efficiency and effectiveness in these kind of multiple public law accountability regimes we now have. You don't always need to argue everything. You can start to take guidance from that body of decisions that's growing, and that's, I think, a tried and true methodology in public law pre-Dore. I don't see why it wouldn't apply post-Dore.
What do we do with the merger of charter values and charter rights into charter protections in Dore? How does that work in your thinking?
And I think you probably have divined by now that the approach I'm trying to advance is meant to try to undo that conflation of the two. I don't find it particularly helpful to say charter protections because I've come up with a new word somehow obviates the need to explore this tension between rights and values. I'd rather we take rights seriously, we take values seriously, and we understand when one is going to be applicable and when the other is necessary.
So if only these two gentlemen were on the Supreme Court, might come up with something workable. So I'm cognizant of the time. I had two questions left for you, so maybe we can merge them into one, because they're both about the sort of practical, how Dore has been taken up and the impact it has on litigants. So, and then we'll move to audience questions, which we want to leave time for. So if you have questions, begin to sort of formulate them and think about what you might want to ask. So the two questions together: what's been the take-up of Dore in the tribunals in the lower courts? And to that end, what has been the impact of Dore or the projected impact on litigants, especially self-represented litigants? A very important question.
Let me do that first. Okay. Yeah. So I have the luxury of a law clerk. Justice Austin has lost his research assistant, I imagine. So I'm told by my clerk that there are more than 200 cases that have invoked charter values in the last 2 years. That's, I would say, a bit of a flood. And it's quite uncertain as to where it's going. So although I would like a rigorous sort of doctrinal development process going on, like as Lauren outlined, I'm not sure that that's actually what's happening in the real world. So let me just explain the categories into which these cases have found themselves. Many of the decisions deal with charter values as an interpretive aid, which I think everyone can agree is not a bad thing. Or, and this is where there's a bunch of cases on the grant test to exclude illegally obtained evidence. So a whole set of criminal cases where that's a factor, and we can set those aside for this purpose. The rest fall into several categories. The first is an appellate decision that actually rejects a decision of a lower court on that has found a charter value, and that's of course the City of Toronto case on the reduction in the number of councillors. The court did not defer to the lower court, did not follow the method you would expect in Trinity Western of deference to the lower court in deciding the charter value and making that decision. The court essentially rejected the idea that effective representation was a charter value. The next is a group of cases urging caution and restraint in using the charter values analysis. I was on the panel for 2 of those cases. And the Supreme Court minority dissent, and actually all 4 of them referred to the cases. Justice Miller and I decided in the Court of Appeal in Ontario. And there's another one of our decisions where this is Justice Miller in a concurring decision, raising the same sorts of concerns. Let's not go to charter values. Let's not, we don't need to. It's just administrative law principles. There is not, as far as I can tell, a real reluctance to engage in charter values analysis of the sort that Justice Sawson was recommending in his submissions. Let's hope that he's true to his own word when he gets these cases. There's also a Manitoba Court of Appeal decision where the same thing was, the court said, no, we're not going there for the reasons that, and it cited our decisions in Ontario. The next is a bunch of cases where the terminology has shifted from charter rights to charter values, but the substantive analysis is the same as charter rights. So I think we have to be careful with terminology. I'm a bit of a textualist when it comes to this. So when you're looking at something like charter values, it's a way to sort of push things together. And I think that has a mischievous outcome in the longer term. But there's a bunch of cases where, from what I can tell, they're still being done in a traditional form. And then there's a bunch of cases which have said charter values are implicated in this case. You, lower court, lower tribunal, did not look at those charter values. We're going to set aside the decision to make you look at the charter values. But by the way, we're not going to tell you what those charter values are. It's very strange, So you have a case where somebody has a charter rights case, and that's disposed of on its basis, and then the charter values issue. The court says, well, you didn't really talk about charter values, so you better go back and do that without actually specifying what the charter values are that might be an issue, which I find kind of crazy, right? But anyway, there it is. So that's the set of cases that as they're unfolding so far. We'll see what happens. They'll percolate up at some point to divisional court on admin law cases and to our court on other kinds of cases and perhaps through admin law cases. We'll see whether or not we end up with developing a body of coherent doctrine quickly. I kind of don't think so. We're not getting really any direction from the Supreme Court on this. Maybe the deference cases will give us some more guidance. I don't know.
So let me be brief and just say this, that, in addition to the analysis that you get to do when you have a law clerk about the recent case law, which is edifying and important, there's another way in which charter values has had a meaningful impact. And having been billed a little bit as a defender of the concept, I don't know that I've lived up to it. So let me say something unabashedly positive about this development in answer to this question, which is what it's done in the other world from which I emerged, the world of administrative justice, of boards and agencies and tribunals. It's led a number of them across a wide area of jurisdiction and statutory mandates to reflect on how charter values engages with their analysis of their statutes and their activities. And it's done so proactively, not when matters are challenged, not in those rare cases where something gets before a court at any level, but in the much more important area of shifting culture, of the training and education of these bodies, and how they come to understand their role. And in these charter values education and training sessions that I've been in as a participant student, as an instructor, and as an observer, you see really important, meaningful discussions about, in our area of policy, in our area of expertise, what are the charter values engaged? Where do they come from? What role does that play in ensuring we are exercising our statutory discretion in reasonable ways? That doesn't involve the full Oakes test. It doesn't even, of course, pre-decide how the balancing may be worked out in reasons by those bodies to the extent they have reasons. But it's been enormously positive as an evolution of the culture in the era of the Charter to better understand the important role those state decision makers play. So that's another kind of impact that we don't often hear because our focus is on the case law. That is the tip of a meaningfully large iceberg, and the majority of it is, of course, below the waterline, and we shouldn't lose sight of that.
Okay, we have about 10-15 minutes for questions, so Lineup Justice Lauwers just wants to say one thing in response to that. We'll keep it brief, and then we'll go to your questions. Yeah,
the question I didn't respond to, and I think this is going to be an interesting issue, and that is, what do you do about self-represented parties? So there are self-represented parties at all levels of court, including our court now. It certainly happened to me when I was a trial judge, and I'm sure that's true in tribunals as well. So if you look at the confusion that there is out there about these issues, and we've spent a few hours this morning talking about this. Imagine being a layperson trying to figure out whether they've got a charter right in the first place, then if they do, or if they don't, what charter values are engaged by the controversy that they have. So my suggestion is, beyond bleating out something obvious like equality or something of that sort, most lay people would have no clue what was going on here. So what's happened in tribunals across the province and in our courts, as well as we've adopted a form of adjudication called active adjudication. And this is where the trial judge or the tribunal member engages in a form of examination in chief of the main self-rep to try and figure out what the problem is, but in a way that isn't leading, in a way that doesn't involve cross-examination. But you can see how the tribunal, including the court, is now going to be required in these settings to go a lot deeper than might otherwise have been the case, to the point where you wonder whether bias becomes a real issue. Active adjudication is always a problem with respect to bias because of the degree of participation of the decision maker in the process. And I can see that this is going to become a problem in the future. We may end up having to appoint amicus and undermining the legal aid scheme completely, but that's part of the problem here.
Okay, questions?
So with thanks to the whole panel, a non-lawyer's or layman's question, not about the correct definition of charter rights and charter values or things of that sort, and not a question about their internal regulation, but their external regulation. So given the adventurous aspect of this area of law, including administrative law, what do you see as the best way in a case where administrative law broadly or more narrowly, the creative use of something like charter values leads to the legal system going ultra vires? How is that ideally corrected externally?
I guess if someone's done something which is clearly unconstitutional, then it gets set aside by a reviewing court. I don't know if I can be any more detailed than that. Maybe I didn't understand the question. Okay.
Well, you know what? Maybe I can help in this way, and this may or may not be what you were getting at. But I think there is an opportunity. I alluded to this earlier for legislatures, for other actors to help assist in clarifying in how to approach these values. We've seen, for example, legislatures have clauses in empowering statutes that remove the jurisdiction of a tribunal to hear and decide charter matters. We have the BC Administrative Justice Act that does this for a whole range of tribunals. We may see more of this to come throughout the country. So there is an important role external to the legal system in working out both what values can mean. We often see legislation now come with a preamble in light of specific charter rights or protections. Here's what the legislation is seeking to do. Will we now see references to charter values as articulated through legislation, either involving the scope of administrative bodies or involving the content? And of course, that itself will be subject to a back and forth in the decision makers' world. But I think there is an important role here always for the elaboration of these ideas in legislative debates, just as there must be in the debates through the courts.
So I think we have about 5 minutes, so perhaps Professor Pardee and one more, and then we'll quickly close. That's okay.
Okay, I have a very short question, really, primarily for Justice Sawson. We had a discussion last night from Justice Stratus about judicial decision-making and the rule of law and so on. And of course, there is room for disagreement about the details of what the rule of law means. But at its essence, we heard that it is the distinction between the rule of law and the rule of persons. So my question is simple. Could you define for us what you think the rule of law means?
Sure. But again, I think for concepts like that, what I try to do is find a wellspring that one can keep coming back to, because the rule of law can't simply be variable on a day-to-day basis, but it needs to be applied in a host of contexts which do change day to day. So the wellspring for me is Justice Rand's decision in Roncarelli. That way of articulating the rule of law may not be perfect. I and others have gone back to it a lot, not always simply to invoke it, but sometimes to explore it and critique it. But there is, in that decision, a line about discretion that I think we should never lose sight of. And it's where Justice Rand says, discretion necessarily implies good faith in discharging public duty. There's always a perspective within which a statute is intended to operate, and any clear departure from its lines or objects is just as objectionable as fraud or corruption. Goes on to say, could you be refused a permit because of where you were born or how you look? For me, that idea of discretion never being unlimited, there always being accountability through law of every kind of state action is the North Star, is the beacon. And again, the elaboration of the rule of law in a host of subsequent settings keeps refining and in some cases adding, in some cases paring from that approach in Roncarelli. But when you ask what's the rule of law to me, that is the point of departure that I continue to come back to. And importantly for our discussion, it's of course long prior to the Charter. This is not news. In other words, that we look to fundamental values in what, again, others have called our common law constitution, our administrative law realm, like Roncarelli, and that doesn't stop with the enactment of the Charter in the 80s. It continues to be an important and parallel, complementary, additional body of thinking about the rule of law.
I take it, though, that the process that you're describing is one that, even if undertaken in good faith, can lead to different decisions by different decision makers in similar situations. I take it that you think that that is okay under a robust rule of law.
I don't think we can use robust anymore with Justice Lauwers, so I take that under advisement. And you know, I think it depends. For me, inconsistency, incoherence, these themselves can be challenges in a rule of law culture, because predictability, transparency, understanding the rules that we're all subject to is a critically important aspect of the rule of law in a constitutional democracy. But yes, I think just as Justice Rand didn't agree what the rule of law meant in terms of the other judgments in the Roncarelli case, there can be smart, principled, public interest-minded decision makers of various kinds who take a good faith approach to the rule of law that doesn't look the same in every case. That needs to be worked out, and ultimately we have 9 good people in the Supreme Court who get the last word on that, but it may not be the final word, or it's the final word but not the last word. Or there's a saying that speaks to the idea that there's ongoing debate, even if that particular dispute needs to be resolved if we're to, again, have the rule of law in a constitutional democracy.
Do we have time for one more? Yeah, okay. So one last question and then we'll conclude. Thanks.
Again, directed to you, Justice Sawson. Just wondering about your distinction in the administrative law context between invoking charter values and charter rights, and what that, when would that analysis be bifurcated? So, I mean, as I read Baker's not a case where Section 7 was squarely at issue. It wasn't, they put the argument to the court, but the court wasn't willing to say, we have a violation of Section 7, now we're looking to the justification type mechanism there. Whereas in Doré, for example, he was arguing very specifically, my freedom of expression has been infringed, there needs to be a justification. Is that the distinction, where somebody's alleging that there's an actual infringement that needs to be justified, or what is the difference between resolving it on the general principles first and then going to the right analysis?
No, I'm glad you asked that question, and because in some of those 200 cases that Justice Lauwers' clerk found, courts have been approaching this as, well, the charter rights analysis is the same. Is there a violation of Section 2, Section 7? That's identical. And charter values is simply an alternative to the Oakes test in talking about justification. This proportionality analysis through administrative law versus the Oakes test. And I think that is part of why we've gotten these two ideas to be, in my view, kind of overly conflated together. That if you simply view it as this is a charter case, and we're looking at whether charter rights have been violated, and then we turn to a different form of justification, then again, I have trouble with the view that we're going to take all charter remedies but for quashing that decision on grounds of unreasonableness and make them never available to any claimant who's been aggrieved in their view by a discretionary decision. So for me, they are two different pathways, even if, again, the point of departure for charter values will always be the text of the charter itself. And I think there are certainly many who subscribe to the view that you could read those cases as suggesting it's a conventional charter rights analysis on infringement and then something different on justification. But again, I'm not convinced that that is the most helpful way to see these for lots of the reasons that Justice Lauwers has elaborated. So again, I think there is raw material in this existing charter values jurisprudence to adopt the kind of approach that I think is better at preserving the good parts from the administrative law approach without giving rise to some of the genuine concerns that have been expressed on the charter application approach.
If I could just say one thing in response. To my way of thinking, I don't like the idea of a bifurcated approach. I think we need to have a consistent approach, and I think that the approach, whether you're going to argue charter values or not, has to be through the Oaks justification process. I think to have a reviewable decision from an appellate perspective, or we need to know whether the tribunal thinks that the limit is rationally connected, or if there is a limit. Does it minimally impair the right, and what other alternatives are there? Is there proportionality between the deleterious and salutary effects? We need to know what the deleterious effects are and what the salutary effects are. Now, I don't have any problem with using a charter value as part of the evaluation process, saying the common good reflects these values. One of them, human good, is, one could argue that a charter value is any human good that is relevant to the decision-making process. I don't think we get very far if we say there are two processes. I think there's only one. I think what the Supreme Court has to go back to is to say, you know something, do the Oaks analysis or some variation on it, but do the Oaks analysis every time, regardless of whether it's an administrative setting or a straight-out judicial challenge, because in order for the reviewing court to understand why you did what you did, even where there are factual determinations that you're an expert at, we have to know what you did. And I think the only disciplined approach is to go down that pipe. So that's where I end up.
I have nothing to add, but this is my last chance to have the last word, so I just want to thank Justice Lauwers for his useful insights.
Well, thank you to both Justice Dawson and Justice Lauwers for an invigorating discussion. I see Scott Reed there and Joanna, so I think that's our cue. Thank you very much.